Hello and welcome to the Financial Wellness Hour. I am your host, Hirsch Sermon, and I am so happy to have you here with us today on WGSN-DB, the Going Solo Network. This show is for those who are wanting to learn more about creating financial wellness, and we will be taking different life cycles, and we're going to explore them both financially and emotionally, because your personal finances are usually not about the money. It's rather about the emotions associated with your finances, and the healthier we are emotionally, the better financial decisions we tend to make. Although we may be somewhat general in our discussions, we'd love to hear from you to make it more relevant, more personal. So please do call in. You can reach me through my website, lifecycle.financial. That's lifecycle.financial. Or you can post your comments and questions on Facebook, YouTube, or wherever else you may be listening. For most, going through a divorce is an unfamiliar process. In fact, I would venture to say there are people that don't actually know there's a myriad of processes one can go through when they're going through a divorce. Understanding each one, choosing the process that is best for your situation is important to your outcome, your stress level, the financial results, and moving on with your life. We do tend to hear mostly about those drawn out slugfests that go through the courts for years and drag back to court. In all my years of doing this, I have never heard anyone say, you know what, we were educated on the best process for us. We are both happy to follow it, and we're on our way. Our guest today, Anthony Diaz, is also the Peacemaker, and we are going to speak about the collaborative law process and why it's a viable option. Tony is a mediator, he's an arbitrator, he's a collaborative law attorney, and he's even more than all of that. Tony, welcome to the show. It's a pleasure to have you on.
Herschel, thanks for having me. It's great to be here.
And I have to ask, the Peacemaker is not the usual moniker that is associated with a divorce. I'm going to ask you to share a little bit about your background, where your passion comes from, and of course, how did you get the name, the Peacemaker?
Sure. Thanks for asking. So believe it or not, and this is, I'm sure you'll be happy about this or interested, I was a CPA in my first career. So I grew up in New York City and went the traditional route, large accounting firm. I did auditing. I went on to numerous positions after that, a CFO, a controller. And after a number of years, I realized I wanted to do something different. I always thought about being an attorney, was a little intimidated about it when I was younger, and decided that, if I was going to do that, I better do it sooner than later. So I went back to law school in my 30s, graduated when I was 40, been an attorney since. Worked at the state attorney's office, did over 50 trials up to robberies and attempted murder, and decided that I wanted to help people a little bit more, and decided to go on my own and open up a family law practice. And been doing that ever since. It's a passion of mine to help people that are in this type of distress, and bringing peace into their lives. So, it's important to me to help people have that peaceful outcome. And that's where I started to be called the Peacemaker by a lot of my colleagues, because a lot of attorneys don't have that skill set of creating peace in others' lives, and I was looked at as being a peacemaker, and it's been where I've been ever since.
I do think there is so much turmoil and so much stress. Any peace you can bring into your life during a divorce process is so helpful. I can also understand after robbery and after murder cases that you'd want to share some peace and bring peace to people's lives. And then one of the things when we've spoken before offline that I really appreciated was it's beyond the parents or the couple getting divorced that you want that peace to be, that it's with the children and the whole larger dynamic as that family dynamic changes, which I think is also so incredibly important, that we don't just think about today, but we really try to look beyond the divorce. What it's going to look like is also so important with that as well.
Yeah, it's and you bring up a really good point that is lost sometimes in the peacemaking, is the effects on generations. And you may have families that have an adversarial outcome in their divorce, and they might miss out on grandparents and other relatives, and miss out on that part of their life that is so nurturing and important in their development. So it's really a little bit more than just the outcome of the divorce. It's more than that.
Yeah, I agree 100%. And, we've spoken about getting educated, understanding your choices, taking responsibility. Anyone who's worked with me or listened to the show knows I'm a huge champion for being educated around your divorce and your situation. One of the things I tell people is be cautious. It's good to go out and read, but you got to be cautious. The laws for every state apply state by state. Someone with a, seemingly similar situation may actually have a very different direction that they need to go, because their priorities and their needs are different, So we're going to focus, as I said, predominantly on collaborative law. I'm going to ask, though, if you can touch a little bit to educate our audience on some of the other common processes for going through a divorce.
Sure. Well, everybody knows the going to court process, and it's been there's many movies that have been made about it. War of the Roses is probably the most common, and I have to tell you, there are some divorces that I've been involved in that had a lot of the characteristics, but there are so many more amicable ways and really more beneficial ways than that. The most common is mediation, and you can do this with or without attorneys. I'm a mediator, and I've mediated cases for folks who don't have attorneys and for folks who do. And it really is it's an effective way of resolving their divorce. You have a neutral professional that's knowledgeable about the law, that doesn't take sides, and helps one go through the options, financial options, parenting options, and that's a creative, low-cost approach. The issue with that is there's still court involved. Either you're in the middle of a case, or even if you don't have an attorney, mediation has an outcome that you need to use the court process to finish up what happens. So there are those who want to avoid court. And the best way to not go to court, have a good outcome, have an end that suits your needs, and you get to decide what that outcome is using the collaborative divorce process that really is the best of both worlds.
So I'm going to ask you to talk a little bit more. What is collaborative law? How does it play into divorce? What makes it appealing? You've already touched on that, really, right? That you can avoid court, but I'm sure there are other benefits to it. Why would one choose this approach over any of those others? And again, that's probably enough questions for the rest of the show, but I can repeat them if you want.
No, sure.
But why collaborative law, and how does it play in, I guess, is really the bottom line of the question.
Sure. So many people have gotten disillusioned with the court process and the adversarial process and not being able to decide their own outcome. So many years ago in Minnesota, Stu Webb was a mediator and an attorney, and decided going to court was not the best way to resolve divorce. And we created a group that would help to resolve divorce out of court. And it was a collaboration of other attorneys and other professionals. And that's where collaborative law was named, because it's basically a collaboration of the spouses, their attorneys, and other professionals, depending on the type of case, to help this couple go through and have an amicable outcome and get their goals met.
Right.
So those who choose the process have a collaboratively trained attorney, which is very important because I'm collaboratively trained. It's been since 2009, and being trained in that way means understanding what's called a paradigm shift, and you go from advocating in court and taking a position and trying to argue for your client to working with the team as a whole, and you still advocate for your client, but you're also taking the other spouse's needs and goals into consideration. You have a facilitator, which is also usually a mental health professional that's used to dealing with conflict and is able to keep this train moving in the right direction. They're also skilled at doing parenting plans. So for cases that involve children, they're the point person to help them create a time sharing plan. And the other professional you use is usually an accountant, a CPA, and they handle the financial part of the case. So what's really unique about collaborative divorce is every professional stays in their lane. You have the attorneys that know the law and can guide their clients along that route. You have a mental health professional that helps with the parenting plan or any conflict that comes up in the case. And you have a financial professional that's neutral, that is able to take in all the financial information and unbiasedly is able to help the couple come up with goals and options with the marital estate. So it's really a best of both worlds to be able to have an amicable outcome, address the goals of the couple, and have an efficient way to move through their process, agreeing not to go to court.
So, just recapping a couple things there, because I think it is important people also understand some of the things that happen in each process. I'm not an attorney, as everyone knows, but I have certainly learned a decent amount, and I have one here to correct me if I'm wrong. But when you go to court, you really lose the ability to negotiate and to share. You plead your case, the other side pleads their case, and then you lose control. The judge makes a decision. When it comes to something like collaborative law, the healthier the discussion, the more that information that is shared, the easier it is to come sometimes to a solution, because you still have the ability to say, I'm not comfortable with that. I think we need to explore that more, or let's look at a different option. And so I think that in itself is a very powerful approach, because too often we feel like we've lost control of our lives when we go through a divorce. Well, this is giving some of that back to you. But again, it comes to being educated, finding the right professional, and then also taking responsibility for your outcome and the process as it goes. Meaning you need to plan for this. You need to, just like no attorney would show up on the day of a divorce in court, they're going to plan ahead of time. So too, would you need to do the same? I mean, any thoughts around that as well?
Sure. So, the creative process, the collaborative process, creates what I call a container. It's a safe space for spouses to be able to talk about what their needs are after divorce. You might have one spouse that has some financial concerns. What's going to happen after the divorce is over? You have two households and two incomes. How is that going to work? how do we co-parent children? Now, in court, the court has no understanding of who you are as parents. It has all these assets. Excuse me. It doesn't know which one is important to who, so it makes the decision, and you may or may not be happy with it. But the collaborative divorce is geared towards making sure at the end of the process, folks get their needs and goals addressed, and you have the professionals there to help make that happen. I want to bring up one more point. Many cases in the collaborative process, once it's completed, never need to be addressed. There usually isn't a conflict after that going forward, because this is an agreement that the couple has made. When you go to court and the court decides what that outcome is, somebody's going to be unhappy, and that usually sets the stage for future court cases, and it just goes on and on and on.
So it's interesting that you said that my approach when I work with clients for the most part is to prioritize, organize, and simplify. And if you know what your priorities are, it's much easier to work towards them and negotiate towards them. That's not the kind of thing that you can kind of do on the fly. I'm in my session now, and we're talking about splitting the assets, we're talking about the parenting plan, whatever it is. You really do need to think about that ahead of time. And I always tell my clients I have a module or a session where I work with them to identify their priorities, because I think that's easy or important, should I say. The not so easy part is identifying what your spouse's priorities might be, because now you're identifying a lot of the difficult conversations, you identifying what you may need to give up in order to get more of the things that are really important to you. But at the same time, you need to be able to communicate these things as well, because if you can't communicate them, whether you're going through collaborative law, any type of process, without that communication, without identifying what they are, you're leaving it up to chance, really.
Mm-hmm.
So I think we have, before the break, little time that we can actually get one more question in before the break. So, one of the things you identified, which I think is so important as well, is often in a mediation, you have just one neutral that is taking care of everything for you. And the collaborative, it's kind of a team approach where you have more than one expert helping you through that specific discipline or their expertise. And we've kind of become a little bit of an on-demand society. We want to know everything, and we kind of want to know it now, right? We're in a conversation, and all of a sudden everyone's in their phones Googling the question that just came up, right? Can you talk about setting the agenda of the meetings, for a collaborative divorce, and how long does it generally take, just so people get this understanding of how the process works?
Sure. So there's a lot that goes on behind the scenes, and the professionals not only meeting with the couple individually or together, we meet together as a team, and we go over what the goals are, what the hot buttons are, what some of the potential landmines are. So each case is different. As a matter of fact, as an attorney, I look at financial and mental health neutrals that will be helpful for this specific case. And when we meet together, it's a combination of all of our knowledge of the collaborative divorce, plus identifying what's important for the client. And we meet before and after every meeting. And that really helps to pre-brief the meeting and also to debrief the meeting, what went well and what could we do differently. So just like cases in court, cases that are in the collaborative process take, however long it takes to go through all the goals. But I would say the average length of a case is anywhere from 3 months to 9 months, where a case in court, the minimum is usually a year, and there is no ceiling. I mean, I've had cases that have gone on for 5 and 7 years. So you really are very efficient with the collaborative process. And I have to tell you, that is really, it's really interesting, because you're trying to come up with schedules for everybody to have a meeting, but we all get it done, and we all get on the same page, and it gets done quickly.
And I want to say usually significantly cheaper than going to court as well, which obviously is a very important piece. You would rather keep as much of your assets as you can, as opposed to spending them on depositions and court reporters and court fees and all the other things that come with that. I would also, before we go to break, just want to say, I've said this often, but just a caution, because divorce can be expensive. It doesn't have to be expensive. But very often the most expensive part of a divorce is your emotions. So always be careful of that as well. We will be back in 2 minutes. We got to pay some bills. And I appreciate you being here, Tony. Thank you.
Thank you.
Hello and welcome back to WGSN-DB, the Going Solo Network. This is the Financial Wellness Hour. I am your host, Hirsch Sermon, and our guest today is the Peacemaker, Tony Diaz, and we are speaking about collaborative law and can it work for you? And I'm going to do a little bit of a recap. Tony, we covered a lot of things. You shared your background. You shared a lot about how you had worked in a court system, obviously, that was rife with adversity, with violence, or the people that have been involved in violence, and wanting to bring the peace to the process. We spoke a little bit about how state laws are pertaining to that state. You need to be very careful and understanding of your situation, of your state, to know your specific needs, your specific circumstances. What are sorry, I can't read my handwriting. What are some of the common processes that you can go through? We spoke about the courts. We spoke about mediation. We obviously delved into the collaborative law process and those differences, and having professionals for each need as opposed to one person covering multiple bases on that. And then we spoke a little bit about the process and going through the process and the timing of it, the potential cost savings, things like that as well. Any quick thoughts on some of the stuff we've covered, or should we just jump right into some of the next questions?
Yeah, so let's move through the collaborative process itself.
All right, great. So at this point, we've kind of covered, people see there's an advantage. They want to look at it. They've got this team on their side, the mental health, the law, the financial team, all working as neutrals, all working somewhat behind the scenes as well as in front of them to make sure that this is a successful process for them. One of the things, though, that I always say to people, it's always easier to get into something than to get out of something. Usually, unfortunately, I'm speaking about debt with that, but in this case, I think it might apply as well. What if the collaborative process doesn't work? We can't come to a conclusion and an agreement. and the divorce is not finalized through the collaborative process. What happens next? And can you touch on some of the items people should maybe be aware of before starting the collaborative process, just in case?
Sure. So I will tell you that the statistics that we have on those going through the collaborative process is less than 10% of all collaborative cases don't resolve successfully. So that's greater than 90%, which is
that's a solid rate of closing those cases for sure.
Exactly. It's and it's important to keep in mind when people go into the process, because it is unknown, like the court process. So each spouse signs a collaborative participation agreement, which has a lot of agreements in there. But one of the most important items is that they agree not to go to court. However, if they do decide to end the collaborative process and to go to court, they have to hire other attorneys. They can't use the same attorneys because there's information that have been passed back and forth that was transparent and didn't use the proper channels, because that's what the collaborative process is. So you'll have to really start from scratch. So what's important to know as you're deciding what process to use and deciding if the collaborative process is for you is it really is for everyone. But you have to decide, are you willing to be transparent? Are you willing to discuss openly some things that might be uncomfortable? Are you willing to disclose where all your assets are? And this is also important. But if it doesn't work, you'll have to start out, in the regular court process. You'll have to start with new attorneys. But I will tell you that part of the agreement really helps to, believe it or not, when people start the process, keep people in the process, because it's not easy to get. It is easy to get out of, but it's what the resources that have to be reused again to start the process. When it gets hard, it keeps people invested. You have some what they call skin in the game,
right?
And it really helps you to move through that, because people are saying, well, do I really want to start again and go to court where I really have hardly any options? So it really helps when people are thinking of jumping ship, of what will happen if they decide to do so. So I think that's important to know going in, that it may be hard and you may want to abandon the process, but there are certain advantages that you lose and some disadvantages that happen if you do decide to go that route.
Right. That's interesting. And I think people should be aware not every process is going to work for everybody, obviously. And, that's part of the education that we spoke about in the first half of the show. If you really understand what's going on, what to expect, I think that rate of 90+% is a very solid, I guess, attesting to how solid the process can be for those people that use it. Now, here's something that I've always thought about because of the finance side. When people give financial disclosures and they talk about the finances and everything, and usually the way it works is one of the spouses takes care of the finances, and the other spouse very often it's not just that they don't take care of the finances, they actually are clueless sometimes about the finances. They, I've dealt with businessmen who are doing fantastically well, but when they come and disclose the information, it looks like they're scraping by day, right? So often, I don't want to say always, but often one spouse is kind of in the dark when it comes to that. What if there is this suspicion that maybe someone is not being totally forthcoming or something to that effect? How is that handled? How would you explore that, or how is it generally explored?
Sure. So I'm going to use the comparison between court and collaborative divorce. In court, what would happen is the spouse that is suspicious of assets missing, being misappropriated, would then hire a forensic accountant, someone who's used to finding assets, and you would hire them, and that's all they would do, and they're not inexpensive. And that would be their job. Now, the other spouse that is being accused of this will now also, hire an expert to support where the money is and where it's going. So the marital estate that's both of them own now are paying for two experts that are butting heads because they're both trying to support their client that has a differing interest, has competing interest. Now, in the collaborative process, you already have a financial neutral that doesn't take sides. So if that concern comes up, one, it's going to be talked about in the team, so everybody knows about it. We're not trying to hide anything. It's a concern, and when we talk about it, now you have a skilled, trained financial person. You're only paying for one. Now we'll be doing the due diligence to go and unravel the finances, and whatever that individual finds, it's shared with both people. Where if you go to court, each expert has a report, and you may not have to share that report. If it's not a good outcome, you don't share it. Where in a collaborative divorce, it's transparent. Whatever the outcome is, it is. And if the assets are being dissipated or mismanaged, we discuss it. Well, how are we going to handle this? How are we going to make the marital estate whole? Whereas if you go to court, there might be a mismanagement of assets, but guess what? The only person to make that decision is the judge, and the judge doesn't always get it right. So the collaborative process is really a transparent process where you can get the answers to those concerns, and you have an individual, a neutral person that is in charge of that.
Right. And, whether it's hiding assets, dissipation of assets, not stating expenses accurately, whatever it might be, I would venture to say, again, not all judges are well-versed in the finance side. That's number one. No knock on them. They are very good at what they are charged to do, which is to manage their courtroom. But I think, the other piece to it is that what I've noticed especially is sometimes a county will have more than one judge handling family law. But if you read the law, sometimes they interpret it a little bit differently. It doesn't mean you're going to get the exact same outcome with every judge going through the same case with the same arguments. They are people. They do have biases. They do come to court. Now, I'm not saying that they're doing anything wrong or that they're trying to be one-sided in any way. I'm not saying that at all. I'm just saying you are dealing with people. They have their expertise. They don't have their expertise. And these are all things that play in. And those are the people, carte blanche, that are making a decision for you sometimes. So you often want to avoid it where you can.
Well, also, when you're in court, you're dealing with evidence. And not all evidence is admissible. So you may have the facts in the case, but for whatever reason, you may not be able to admit them before a judge and get them entered into evidence. And that's a legal procedure. When you're in the collaborative process, it doesn't matter whether it's admissible or not. The facts are the facts. You don't need to be a great orator. You don't need to try to use the law on your side. This is what works for the couple, what is right, and what do they both want as an outcome. And judges are great. They are astute and adept at the law, but they're also constrained by the law and by the admission of evidence, and that doesn't always help when you're dealing with assets and where they are.
Right. No, very, very good points. Very, very good points. So everyone's up above board. Everyone's saying what it is. What are some of the hurdles then when you're transferring assets? And what are maybe the mistakes or errors that people make when splitting the assets?
Sure. So many times when there's a divorce about to happen or somebody's about to filing a petition, you have one or more of the parties coming from a place of fear starts to move money into other accounts. They're afraid the other spouse is going to spend it. They're afraid they're not going to have money for attorney's fees. So all of a sudden, money starts moving, and it happens all the time. One of the pitfalls is if they use a retirement account to go ahead and do that. And let's say they don't have any cash, but they're afraid of the other spouse going into the retirement account. Well, as you know, there are potential tax implications of doing that, not only tax, but penalties. And it's very hard to unravel that, whether you're in court or in the collaborative process. So one of the things I advise everyone is investments, cash, assets are in a marital estate. If one person decides to move it, if you go through the collaborative process, that money will be accounted for. So I always tell my clients that are coming to me to file for divorce, please don't move money. Please don't hide money. It's going to get accounted for at the end, but it creates a mistrust when that happens before or during the divorce. And even if you're in the collaborative process, if that happens, well, now you're not going to trust what the other spouse is saying or doing. You have a place to discuss it, but there are people who don't have the financial knowledge, such as yourself, really need to be careful when they start trying to move around assets or cash in assets that may have a tax implication.
I think it's so important. I even tell people, let me read your settlement agreement, the dissolution agreement, before you sign it, because there are sometimes things put in there that either will trigger taxes and they don't even realize it. There are times where there are things that are put in there that absolutely cannot happen in the time frame that they put in there. You know, one example is if you are reliant on maintenance, which used to be alimony, generally you have to have 6 consecutive payments of that maintenance. I've seen, dissolution agreements that will say, oh, you got to refinance in 90 days. Sounds reasonable, but it's just not going to happen because they haven't received 6 months worth of payments. You know, things like that. I would just throw in, then this is just general considerations, establishing an agreeable value on the home. I think that's a big one. Is somebody going to buy the other one out? How do you work with retirement accounts? And you got to understand each individual one. For example, an annuity, is it in the accumulation stage where it's still building? Is it in the payout stage? Very, very different asset when it's in the payout stage. Or dealing with a quadro, which is basically helping retitle. I'm going to use very non-legal language here. Retitle a retirement account. You can use that to avoid some of the penalties or the taxes that would be incurred. But know what you're doing. I always tell clients, create a checklist from your dissolution agreement. Know exactly when everything has to be done. I had somebody that had a quadro, was supposed to receive a bunch of the retirement assets. And you know what? It was 4 years later, and they decided they were going to execute on the quadro. They lost out on 4 years worth of growth on those assets because they had to do it by a certain period of time. And that's when that number was locked in.
Well, also, like yeah, I mean, those are extremely important considerations. And again, because I believe in the collaborative process and all the advantages it does, having the financial neutral that is usually a CPA. What I do in my case is, if I can see the marital asset has a lot of assets that have tax implications, I will make sure that the financial neutral is strong in that area, because there are going to be decisions that have to be made, and you don't want to have to sign an agreement and go back and say, oops, because it's not as easy to unravel agreements. So get it right the first time, and make sure that that every asset is looked at with a tax implication, because that will affect the distribution of the assets. You know, every asset isn't created equal, and you have to understand, and you know this, of course, that if there are tax implications on some assets and none on others, they're weighted differently, and it's not every asset is created equal.
Right, absolutely. I had a client that had 130,000 in traditional IRA. They had 110 in a Roth IRA that they'd had for, I don't remember, 7 or 8 years. So they passed the 5-year rule, all of that. I suggested they take the 110, not the 130, because it's at that point tax-free for them. You know, so absolutely. All right, so we're going to start wrapping up, but I think it's important people also understand, just, you know, they need to be comfortable with their professional, and they need to understand it's more than just the technical ability of that person, but being comfortable with them as a professional, and that they're going to be the right professional for them is important. Can you talk a little bit about, for lack of better wording, your intake, getting them acclimated, starting the process with clients so they understand the journey they're about to take?
Sure. So I spend a great deal of time with those that are interested in going through a divorce. Either they've decided that's what they want to do, or need more information. In Florida, attorneys are required to go over every option that's available to clients for divorce. And I look at their individual situations and I make suggestions. Of course, I believe in the collaborative process, but ultimately the client needs to make a decision on what's correct for them. But my job is to make sure that they have all the information. If they decide to go through the collaborative process, you know, I go into more detail. Here's how a team is arrived at. Get their input on the type of facilitator that will be important, the type of financial person that'll be used. I also would direct them to other attorneys that are collaboratively trained for their spouse, to make sure that their spouse has someone who's very experienced in the collaborative process. But all this is part of an education with the client, and making sure that they have all the information that is necessary, you know, for them to make an educated decision.
I think that's so important, because generally you only have one chance to go through this, and you want to get it right. But that education, I think, is invaluable. And again, understanding those options, not every state, again, this comes back to the laws state by state, or how things are handled state by state. That's not the law for every state. So ask that question when you're in a different state and they're not running through all the options. You have every right to ask, what are all the options I have? So before we wrap up, I'm going to ask, how should people reach out to you? How can they contact you if they want to learn more or start to work with you?
Sure. So if they want to contact me, one place is my website, which is anthonydiazlaw.com, www.anthonydiazlaw.com. They can also email me at anthony@anthonydiazlaw.com. They can also reach me for a consultation at area code 407-565-5908. Again, I'm a Florida attorney, but I can mediate and collaborate in any case around the United States. I'm not locked into Florida.
Wonderful. I appreciate it. I appreciate your insights. I encourage people to reach out to you, to learn more, to use Anthony, have some peace in that process for you. I think is so important. I am Hirsch Sermon, your host for the Financial Wellness Hour. Please reach out to me through my website, lifecycle.financial. That's lifecycle.financial. You can reach out to me with questions for myself or for Tony Diaz, our guest today, the Peacemaker. Thank you, CC Schatz, for producing, and the magic behind the scenes makes it very easy to bring this information to everybody. I look forward to you joining me on my next show. Have a great week. Thank you.